going to be this morning's in-house in focus. And as usual with these in-house in focus sessions, for those who haven't been here before, we have a few housekeeping things to cover at the start. So the first is to say we'll be recording the session and we'll be circulating the recording afterwards with the slides. So if there's anything that you've missed, don't feel you need to be rapidly writing things down as we go. And if you've missed part of the session, you can always listen back to the first few minutes that you missed later. The second is we've got a Q&A function as usual on Zoom, and so if you did want to ask any questions, put them in the Q&A. Only Emma and I will be able to see the questions. Nobody else participating will be able to. We'll try to answer questions as we go. It's quite possible we won't have time to answer all the questions, so if there were questions raised we didn't have a chance to answer, if you put your name on the question, we'll be able to follow up with you later. As I say, also, obviously, there are opportunities to just contact us separately if we run out of time to address things today. And lastly, from a housekeeping point of view, we've also got a feedback survey as usual. So after the session, if you want to let us know how you found the session, obviously, but also particularly any thoughts you've got on what else we could cover in future. We do look carefully at that feedback in terms of planning our other future sessions, and in fact we have an in-house in focus planning session coming up soon, so it'd be very helpful for us if you could let us know what else you'd be interested in hearing about. So today we're going to split the session in two. We're going to do a data protection update from me first, with really high-level news on data protection things that are happening at the moment, and then I'm going to hand over to Emma roughly halfway through to talk about freedom of information and some of the key things to be aware of from both the public and private sector point of view. So I think I will then kick off with my data protection update. So my aim here, I've got about 10 minutes to cover data protection. As you can imagine, there's quite a lot happening, and so I'm not going to be going into huge detail here. This is more what are the key news things we're seeing out there that we're talking to clients about, or that we're following that we think may affect direction of travel in data protection. So I'm going to talk briefly about the new IDTA, International Data Transfer Agreement, and the addendum to the EU's SCCs. I'm going to talk a bit about those SCCs and the implementation of the Schrems II judgment. I'm going to talk about our new Information Commissioner, talk about the DCMS consultation about the future of data protection law in the UK, and pick up on a few other themes that we're seeing come up frequently. So first on the IDTA and addendum, and very topically, so we have a new international data transfer agreement that's been published by the Information Commissioner's Office to govern international data transfers out of the UK. And the ICO has also published an addendum to the European Union's standard contractual clauses as an alternative to the IDTA, and they've been in circulation for a while, but they came into force this week, and the ICO has made clear now, since for the last month or two, that people can be using those anyway, and certainly we know a number of clients that have been already using those IDTA and SCCs in practice as a pragmatic thing to do in advance of them officially being in force. But so that's something that we're seeing a lot of people getting in touch with us about, to implement those afresh or to ask about how to complete them, where they've got some questions about that. And there is useful guidance from the ICO about how to use them too. I'm not going to talk about them in a lot more detail. I'll come back later. There's a separate session Mills and Reeve are running next month, going into a lot more detail about those documents. secondly, and along similar lines, we've got the European Union's standard contractual clauses, which have been around since last year. So these replace the old standard contractual clauses, which we've been using for many years. And the advantage of the new standard contractual clauses is you don't need a separate DPA. They cover the Article 28 requirements of the GDPR as well as the international transfer requirements. And they also allow for a number of different scenarios that were not covered under the old SCCs, so processor controller, processor, and so on. And so we've now, for transfers out of the EU, though those are what people are using, transfers out of the UK, you've got the choice between using the IDTA or the new SCCs plus the ICO's addendum. And it's fair to say, I think we're seeing a lot of people choosing to go with the SCCs plus addendum where they are multinationals with operations across the UK and the EU. At the moment, they're enforced and people are able to use them and should be using them for any new arrangements. They should also be replacing any old SCCs by the end of this year with the new SCCs. So again, we've got clients getting in touch about projects to remediate effectively old SCC supplier contracts during the course of the year. So if you're not looking at that already, either that's something that you ought to be thinking about, or you might find that you have people getting in touch with you asking to update old contracts to replace those SCCs during the course of the year. So again, I'll come back later about a separate session we're running looking into those international transfer arrangements in a lot more detail. We've also got a new information commissioner in the UK. So John Edwards was appointed in January, and he was previously carrying out a similar role in New Zealand. So he's been appointed for a 5-year term, and he's talking this week, in fact, at an event, one of his first external speaking events. So hopefully, I think possibly even today. So we should, I suspect, see headlines during the course of this week about some of the things that he's seeking to address in the course of his time as commissioner. A couple of things he said when he was first appointed to give you an idea of the sort of things he might be looking at. He said he wanted to make data protection easy. There's a challenge, but he also said, and I wonder how telling this was in his appointment, that New Zealand is not identical to the GDPR, but it is recognised as adequate in terms of the ability to make those international transfers. And I think it's certainly a priority for UK government to look at how we can keep our adequacy decision in terms of transfers from the EU, but also find opportunities to update GDPR laws. So that, I suspect, might be a theme of his discussion of his discussions this week. And on that subject, we've also had a recent consultation from government. So DCMS had a consultation, Data a New Direction, looking at where we should be updating data protection laws in the UK. The idea being, post-Brexit, we don't have to have identical laws to the GDPR, that we more or less do at the moment, subject to the tweaks under the UK GDPR. And so government is saying, well, what can we do to update our laws where there are opportunities to do that without putting at risk that adequacy decision? And so there are a number of aspirations in the consultation paper looking at reducing the burden of compliance, moving to a more risk-based accountability approach. So, for example, instead of mandating particular roles and documents and processes, leaving it to organisations to determine their own processes that are more, as they say, risk-based and appropriate for their circumstances. It's also intended to boost trade and reduce barriers to data flow, again by streamlining some areas of GDPR, and address some new technologies, things like artificial intelligence, where there are some challenges for organisations implementing the technology to understand how the current laws from a data protection, and particularly the overlap with, for example, anti-discrimination laws, how do they work together? As I've said a few times, I think the challenge here is to get that balance right between opening up opportunities and making the existing rules more streamlined, reducing the burden of compliance without losing that adequacy decision. And certainly we've seen when talking to clients about the consultation, one concern for multinationals is how you retain that how reducing the burden of compliance in the UK actually reduces the burden of compliance where you're already having to comply with the EU rules for your EU operations. And certainly some people are saying, well, we'll keep going to the highest standard, and if that's the EU standard, that's what we'll do. And there are some also pretty sensible bits of the consultation looking at opportunities to tidy up anomalies, things that were not fully addressed in data protection law, where they can be tweaked to make things easier in terms of, for example, sending data back where it's come from without having necessarily to put in place IDTA, SCCs or similar. So DCMS is expected to publish a response to the consultation in the spring. So it feels very spring-like today, so maybe it's on its way soon. And I'm sure there'll be a lot more discussion about that once we've heard their response. And then I thought, finally, I'd just touch on, in no particular level of detail, some other themes that we're seeing still come up or come up afresh from clients in recent times. So we're seeing a lot of discussion about cybersecurity, particularly perhaps unsurprising in the last month or two with what's been happening in Ukraine, and unsurprisingly, perhaps the Information Commission has been asked a number of questions around cybersecurity and what people can be doing to protect themselves. For example, looking at what security guidance is out there. So, for example, the Cyber Essentials as a standard that people are expected to comply with when they're appointing partners, suppliers, and so on. So that's come up quite a lot. We've also seen the ICO continue to look at online advertising technology and some of the guidance around what is and isn't possible there. And we're also seeing a lot of discussion around the ICO's data sharing code. So, I mean, that's been around for a little while now, but we're still seeing people looking at understanding the implications of that code for their data sharing arrangements. And to remind you, that's just addressing controller data sharing. It's not about appointing processors, but it does have some guidance on what typically you might expect to see in a controller data sharing agreement. And it's fair to say often people are grappling with what's a proportionate level of detail to go to when putting those data sharing arrangements in place, and how far they need to reflect the full recommendations of that code. And we're also seeing questions around the kids code, children's code, or the age appropriate design code, looking at adjustments to make in the context of processing data relating to children, and some of the challenges around capacity and consent and the involvement of parents and guardians, and that's come up quite a lot recently. And I thought I'd also mention again artificial intelligence as a developing area of technology where the legal issues are quite knotty. Again, could do a whole separate session on that, but that's a question that's come up quite a lot as well. So that's all I wanted to cover. One final thing to mention, on a couple of times on the international transfers, I said I wasn't going to go into huge detail, and I can see a few questions coming in from some of you. If I get time, I may come back to those, but otherwise, if you want to know more, we have got a session purely focusing on those next month in more detail. So unraveling the mysterious world of international data transfers, Jagvinder's running that session. to look in more detail at the IDTA and so on. So that's on the 22nd of April. I've got the link on screen. You probably just as easily track it down through the events page of our website, or otherwise when we send the slides around, use that link and you should be able to find it. So that is it from me, and I'm then going to hand over to Emma, who's, for those of you who don't know her, Principal Associate in the team, who focuses on freedom of information as well as data protection issues, and has been, well, we were talking about it earlier, has been working on freedom of information issues for 20 years, and it is my first port of call when FOI things come up. So on that note, I'm going to hand to Emma, and she can signal when she wants me to change slides.
Thank you very much, Peter, and good morning to you all. I'm going to spend the next 10 or 15 minutes or so thinking through what's often regarded, I think, as a forgotten sibling of the probably more pacey data protection legislation, being the Freedom of Information Act 2000, or FOIA, as it's often known. Now, to set the scene in very basic terms, I like to think of FOI as operating as a fine cake shop, as you can see on my slide just now. So there'll be a range of cakes presented to customers, and they might happen to choose those which are on the counter to savour and take away and relish them. But if I, as a customer, had something very particular in mind, I might happen to ask the friendly shop person to go into the back of the shop and see if they had that particular cake. And if they didn't, I might even go as far as to ask them to go and prepare it if it didn't take too much time and effort for them to do that. And to bring us back to FOI rather than cakes as we approach coffee time for some of you, the analogy is intended to represent the dual nature of the public access regime which the FOIA presents. So both the requirement on public bodies to proactively publish certain information under what's known as a publication scheme, but also to respond to specific requests for information for really anything which the public might wish to see. And the information can be very, very wide. So although we tend to see trends of requests across different sectors and across different time periods, the FOIA has potential to impact on, I think, almost every aspect of your organisation's operations, from the very obvious commercial types of information such as contracts, pricing, and business models, right through to the far less obvious and sometimes very, very left field kinds of requests of information that we sometimes see crop up. Now, naturally, FOI is going to have more of a direct bearing on your organisation if it is an organisation which is subject to the legislation itself. But even if your organisation is not subject to the FOIA, unless it has absolutely no involvement with bodies that do, and that's even indirectly, the legislation is going to have an impact on it, meaning that, in my opinion anyway, this is a really important aspect of informing your relationships with third parties, particularly with reference to expectations around information holding and the limits that can be properly placed on keeping information confidential. So with that in mind, I'm going to canter quite quickly through three, I think, important questions today. And my next slide, if Peter could turn to it, is the first question that I want to look at, which entities are subject to the legislation. Now, generally speaking, it's relatively easy to ascertain whether a particular entity is subject to the FOIA, albeit that you sometimes have to work through different tests. The FOI applies to what we call public authorities and what the legislation refers to in that respect. And just as an aside, many of you will be aware that the term public authority is used across a range of different legal disciplines, and there are different tests depending on, for example, if we're thinking about if this is an entity subject to the Human Rights Act or a body amenable to judicial review. For our purposes, for considering FOI, we need to look to Section 3 of the Act, which provides that there are three ways in which bodies can become subject to the FOIA directly. which are listed on the slide just now. So the first is that the entity is expressly listed in Schedule 1 of the Act. It's a relatively long schedule to have a read through at your leisure, or not, but it will list some bodies that you would tend automatically to think probably FOI would apply to, so government, NHS, further and higher education, and some specific non-departmental public bodies. The second way of becoming subject to the FOI is if you're designated by order, and UCAS, for example, was designated as subject to FOI a couple of years ago through that route. And the last possible way that you need to think through whether an entity is subject to FOI is if it's a publicly owned company as defined by Section 6 of the Act, meaning that the company is wholly owned by the Crown and or the public sector itself, so bodies themselves which are subject to the FOI. And sometimes that publicly owned company aspect can catch people by surprise. It's always worth bearing in mind the publicly owned company elements to the definition of public authorities. So that very briefly is the scope of the entities which are subject to the FOIA. I'm conscious of time and I don't want to delve into this in too much detail because it's probably a topic of itself. But one thing just to bear in mind is that if you're thinking about environmental information as defined within the Environmental Information Regulations 2004, which are similar to FOI, but obviously deal specifically with environmental information, there's a wider definition of public authority under that legislation. So potentially have entities which are subject to the EIR as they're known, but not the FOIA. And again, if you're thinking about any kind of environmental information, which is defined very broadly, so things like planning, emissions, etc., you also need to be thinking about that legislation too. Next slide, please. The next question that you need to be thinking about is what information when is information held? I think we might have skipped forward, Peter, sorry, one slide.
Sorry.
There should be a when is information held.
Okay. Sorry. Yeah, I think we're missing a slide, sorry.
Okay, we might be missing a slide. So essentially, information is caught and held if it's held by or on behalf of a public authority. So at a very basic level, if a public authority holds information to any extent for its own purposes, it's going to be held for the purposes of the Act. Equally, if a third party holds information on behalf of a public authority, it's going to be held. But on the flip side of that, where the public authority holds information solely on behalf of another person, it's not going to be held for the purposes of the Act. Things aren't necessarily always as cut and dry as that, and the Information Commissioner's Office, which like data protection also regulates FOI compliance, has published some really helpful guidance summarising its enforcement approach. So, for example, if the information is, as a matter of fact, held in some capacity by a public authority, but there's a dispute as to whether it's subject to the FOIA, the ICO suggests that we should be thinking through factors such as, does the authority control access to the information? Does it decide if it's retained, altered or deleted? And do the costs arising from holding the information feature within the authority's budget? Beyond that, there often arise issues such as whether particular information is held by public authorities. So as a very basic example, a public authority might receive a request for a log of communications with a contracting entity over the last 3 months, for example, and it might not hold a schedule of its own accord, so it might not have a particular document which lists out those communications. And the test in that scenario is whether the public authority can generate the information sought using building blocks without any complex judgment. So in that kind of scenario, you can see that it's probably quite easy to look to its record of emails, for example, and to make that information to respond to a request. And beyond that, there are also sometimes some quite narrow points about information being held around, for example, if information is held on a read-only basis by a public authority. So in certain factual contexts, that's been determined as not being held by a public authority. And there are also some complexities around deleted content and whether that is subject to the FOI. So you get into some quite detailed questions at this point. And again, the ICO has helpful guidance on that. So if you're an organisation which isn't subject to FOI, all of these factors are going to have a bearing on the basis on which you want your information to be shared with the public authority, which is subject to FOI, which I'll come back to you shortly. Next slide, please. Now, the third question, which is obviously hugely important when we consider the public-private interface with FOI, is the extent to which exemptions from disclosure lawfully apply. Because very simply, even if information is held by a public authority, it's not necessarily required to be disclosed to the world at large, which is the legal effect of disclosure under the FOIA. There are a range of statutory exemptions from disclosure under the legislation, which I've jotted down the slide. I'm not sure if you can see them. Hopefully when the slides come around, you'll be able to see them a bit clearer. Some of them are what's known as absolute exemptions, meaning that if the exemption is engaged, the information can be withheld. Others, so a larger number, are what's known as qualified exemptions, meaning that if an exemption applies, a public authority still needs to go on and consider the balance of public interest, both in favour of maintaining the exemption and in giving disclosure. And generally speaking, when we're looking at third-party involvement in requests, the exemptions which often tend to apply are things like Section 40, which enables a public authority to exempt information where disclosure would place it in breach of data protection legislation. And also the coupling of Section 41, which provides an exemption where disclosure would constitute an actionable breach of confidence, and also Section 43, which provides an exemption where disclosure would be likely to prejudice the commercial interests of any person, which can include the public authority itself. But it's always really important, I think, to stand back and consider exemptions afresh on each particular request, because sometimes less commonly used exemptions might be applicable. And also, generally speaking, the ICO and the tribunals and the courts thereafter have made it very clear that public authorities need to look at information on a line-by-line approach rather than a blanket basis. So some of the wider exemptions can sometimes be really helpful rather than looking too narrowly at those particular exemptions. Consulting with third parties potentially affected by disclosure is going to be an important feature of navigating exemptions, and that's so for a number of reasons. The first is from a technical regulatory perspective. Almost every exemption requires evidence from a third party's position rather than the public authority merely speculating on what they consider that position would be. And from a practical perspective of managing your relationship with that third party, it also enables them, or you, depending on which you are, to be involved appropriately in the process. So if you're not the public authority dealing with a request and you're approached by a public authority who is concerned that you might have an interest in the information, it's really in your interest to engage in the process and to articulate your concerns as clearly and concisely as possible, because ultimately the public authority, which is the body subject to the disclosure regime, is going to be required to assess those objections with a view on reaching a positive decision on whether disclosure is necessary. Next slide, please, Peter. So just to wrap this all up and just think through some practical implications, both from the public and the private sector, of what FOI might mean to you as an organisation. The ICO has published some really helpful guidance, again, on outsourcing, which I think has application across a range of third-party relationships dealing with information handling. So beyond just contractual outsourcing, but any kind of relationship which a public authority has with another entity. And the guidance recommends that the parties approach outsource information on what's known as a transparency by design basis. And that entails 4 key themes. The first is making information proactively available. So public authorities need, under their publication schemes, to publish certain information, and it's just navigating what that should and should not be. Agreeing what information is held for FOI purposes. I've touched on that earlier, but if you're dealing with information provided under a contract, looking at the contract and thinking through practically on the ground, what is the information that the public authority is going to hold, so there are no surprises further down the track and expectations are managed. Setting out responsibilities in handling FOI requests. Often contracts will include a clause dealing with how the public authority will respond and the consultation requirements, which will come into play, but just thinking through what's expected of the parties concerned. And finally, considering in advance what information may be exempt from disclosure. So looking at the information that's held within the scope of that contract or that relationship, looking at the exemptions which are available under the Act, and which I've jotted down on the slide just now, and thinking through the exemptions which may be applicable. So you can never agree up front that information will always be confidential, for example, because it will lose information may lose the quality of confidence over time, but just sketching the parameters so that both parties are aware, broadly speaking, of what the position might be if a particular request is received. I'm conscious that was a very whistle-stop tour. I'm going to pause at this point. I can see that we've got some questions that have come in, so I will pass back to Peter at this point. Thank you.
Emma. Actually, can I start with a comment / question for you? But because it's probably of the things you've just been talking about, the bit that most often crosses over into my world is the point you were talking about with the putting out in the contract about what responsibilities there are for handling FOI requests and/or being as helpful as possible to the authority if you're an organisation that's been asked about having their information shared later. I think it's fair to say, isn't it, certainly from what I've seen, that when private sector bodies just give a blanket, we think everything we've given you is commercially sensitive and confidential and you mustn't disclose any of it, including, for example, public published brochures, standard form contracts that everyone's already read and so on. That's actually not as helpful as you said, being more specific about the things that really are commercially sensitive, whether that's pricing information or whatever. So actually being more specific is more helpful to the authority and more likely to result in the authority not disclosing those things. Is that a fair?
Yeah, absolutely. So I think you're absolutely right. So you need to look at information on quite a granular basis. If information is already in the public domain, in a sense, what's the exemption that you're looking to, because it's not going to be confidentiality, for example, because it doesn't have the necessary quality of confidence. And the ICO and the tribunals and the courts have all been very clear that it is a line-by-line basis, and you're, in a sense, a public authority should be approaching things from a perspective of what can it disclose rather than what it can't disclose. Testing, in a sense, standing back and testing, it's probably, generally speaking, there may be schedules within a contract, but ordinarily you're looking at more, words and lines rather than the whole contract being blanked out. And from that perspective of the collaborative relationship between the two parties, obviously, the more the other party can help the public authority in making the argument and building the case, the more helpful that's going to be in terms of protecting their information. But yeah, a blanket objection is perhaps not the most helpful approach in all circumstances.
Yeah, that's what I thought, and we do see those, don't we?
Yeah.
There can be a slightly naive view that I just want to stop everything and I can't be bothered to engage with it. And actually, the truth is, that can work, but more often it's you're more likely to get the desired result by being specific, and that helps both parties.
Yeah, absolutely. Yeah.
Cool. Sorry, jumping in with my own question. As Emma said, over to questions. So I saw that a couple come in at the start, which I'll pick up on the crossover between the IDTA and the EU SCCs, which is the question of, do we need both? So the answer is broadly no, you don't. The idea is that they're alternatives. So if you're transferring data from the UK, you wouldn't need both EU SCCs plus addendum and IDTA. And if you're transferring data from the EU, you would only need the EU SCCs. So the idea is that the EU SCCs plus addendum is an alternative to the IDTA where you are transferring data from the UK. A situation where we see this sometimes come up is if you've got, for example, a multinational company doing data sharing across the group, and you may have multiple entities across the UK and EU exporting data. We do sometimes see a form of data sharing agreement where you would have the EU SCCs in one schedule applying to export from the entities in the EU, with an additional UK addendum in another schedule applying to the transfers out of the UK. As well as those EU SCCs. So hopefully that answers the question. I'm just looking at the questions. I think that's I think that covers the first couple around those transfers. There was a question around the use of old SCCs at the moment. So ICO is publishing guidance on a transition timetable in terms of moving away from the old ICO. Sorry, step back. Before the IDTA was published, we had the ICO's UK version of the old EU SCCs. That was the ICO's recommended approach until the IDTA had been published. So if you're using those either old EU SCCs or old UK amended SCCs, then you will need to transition to the new ones. In terms of the transition, if it's an EU export, that transition is, as I said earlier, needs to be done by the end of this year. Otherwise, it technically wouldn't be compliant. Where you're using it for a UK export, the transition details that the ICO is publishing at the moment will apply, and I must admit I don't know the date off the top of my head for the transition period for the export from the UK, but I think the expectation is that there will be a requirement to transition away from those old SCCs within a period of time. I mean, as ever with these things, in terms of levels of risk, if you don't transition within the deadline, it's still having old SCCs will be better than having nothing in place in terms of that transfer, and that will the level of risk will obviously depend on the nature of the data being transferred and the volume of data and all the usual things we think about when making that decision. But technically, there will be a requirement to move away from those old ones. Next one I was going to comment, I think it's probably what one for you, Emma. A couple of comments about information held on behalf of a public authority. So you can see the comment: if you hold information on behalf of a public authority, you're also caught. I don't know if there's anything particular that you wanted to comment on that.
Yeah, I would agree. So obviously if information is held by another entity for the public authority, then that would be caught as well. And I can see there's also a question around section 40 and the way that that's being tackled by the ICO and the tribunals. I think, sorry, I'm just going to go back to the question. So there seems to be a trend from the ICO for FOI to be starting to trump a section 40 exemption, with recent case law saying that it's only if someone is identifiable from the information provided. So section 40 obviously provides that information is exempt from disclosure if giving disclosure would breach data protection legislation. And obviously for it to apply, it has to be personal data of one or more individuals. And you would need to consider whether giving disclosure would be fair, lawful, transparent, and generally comply with the data protection legislation, which obviously is very fact specific. But, you know, and there's been a range of cases, you know, right the way up to kind of the disclosure of senior staff salaries and whether that's lawful from the perspective of personal data legislation. But if you get to a scenario where the ICO or the tribunal is scrutinising the decision to invoke section 40, you have to go right the way back to the basics and obviously, you know, think through, is this personal data of an individual or individuals? And is there going to be a lawful condition for processing by giving disclosure? So, you know, is it going to be, is there an Article 6 condition, for example, which is engaged? And if there isn't, then Section 40 is probably going to fall away. I can see there's also a question about the application of FOI to schools. So FOI does apply to schools if it's in the maintained sector, for example, or academies. It doesn't necessarily apply to every school if it's the independent sector, for example, but generally speaking, it would apply.
And there's another one, I don't know if you've seen, and I don't know whether we've time to address this one, but broadly there was a question around where there was a request for a large volume of information cutting across the cost threshold, where the authority might decide that it didn't have to provide all that information because of the cost of providing it. Broadly, the question being, should we refuse the request because it would cost too much to comply, or should we get in touch with the requester and say, do you want part of the information because we can provide you this part within what you're entitled to, but I'm afraid the rest would cost too much, so we're not going to do that. What problem is, that's probably quite a good decision, but
no, so very briefly, so there is a provision under section 12 of the Act relating to the cost of compliance. So if it's going to take in excess of what the appropriate limit, which depends for different kinds of public authorities, but it's 18 or 24 hours for searching for and retrieving the information, you can say that it's exempt under the cost cap provisions. But and I haven't read the question in full, but the point about going back to the requestor is really important because that ties in with the aligned duty under section 16 to advise and assist requestors. So going back as a point of good practice and saying, you know, we've looked at your request, we think it's going to exceed the appropriate cost limit, but in accordance with our duty to advise and assist you, we could tell you that if you narrowed your request to X, we're likely to be able to deal with it, is a good strategy in terms of managing the section 16 duty to advise and assist requestors as well. And there's some helpful guidance published by the ICO about the cost cap on the ICO's website.
Brilliant. Thank you very much. Well, I think we're out of time at that point. So I think there was one more question I was going to not answer by just commenting on. There was a question about do we think privacy shields are going to be replaced, or a new privacy shield might be on the horizon, or is it a long way away? And I'll be honest with you, I'm only answering it because I don't know the answer. I think there'd certainly be an aspiration to put something new in place. I don't have any up-to-date news on if and when that might happen. So if anyone who's attending knows more than I do, put it in the Q&A if you know more, and we'll cover it when we come to the session in April. Okay, I think we're out of time. So thanks everyone for coming along. Enjoy the spring weather if you're in the UK and got the spring weather. And as I said at the start, please do fill in the feedback form, particularly obviously how we did, but particularly useful on what else might we cover for next time would be great, even if it's just a couple of words. Super helpful. Thanks very much. Have a good day.